Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning and welcome to our SpringLaw Spring Forward Legal Update webinar series. We're now in November 2020 and we've done a lot of these all year, in part because of how frequently the law changes around COVID, and we'll be addressing that again today because we have a new law to talk about that passed this week. So today is our topic today is winter is coming, covering your employer ass as we all head indoors. My name is Lisa Stam, and I'm one of the lawyers at SpringLaw. Presenting with me is Hilary Page. We are employment lawyers and contract lawyers at our virtual law firm, SpringLaw, where we help bosses build and manage their people law systems with more calm and less drama. For more information on our firm, come visit us at www.springlaw.ca, where we have a variety of resources for employers, including our award-winning blog, which Hilary takes a lead on. So anyone who's been on there will hear Hilary's voice in many of the blog posts. A link to our monthly newsletter if you'd like to receive our monthly information updates. More information on our innovative subscription program for employers, and our ebook for employees who have been recently fired and are looking for some help with a more affordable DIY option. So that is, and then there's a bunch of other resources on there as well. So let's jump in. Today we're going to talk about the infectious disease emergency leave more and again. We're going to talk about other accommodations as people head indoors, and as we were able to really pivot out and do a lot of outdoor activity to really help with dealing with the impact of COVID. And our Canadian winter is settling in, snow on the ground today, and so we're going to talk about what those big picture issues are as we are heading into our Canadian hibernation. We'll also talk about this new law that passed this week around employer liability issues and business liability issues, and then layoffs and terminations, and then hopefully we have time for a bit of a Q&A at the end. Over to you, Hilary.
All right. Yeah, sounds good. So I will start us off with a quick overview of the infectious disease emergency leave. So this we talk about every webinar, but it is kind of endlessly applicable during COVID. So here we go. So the infectious disease emergency leave, or the IDEL as we call it, it's an unpaid leave for reasons related to COVID. So employers are often being presented with employees who aren't able to come to work or don't want to come to work, or some barrier to working due to COVID, and this remains an option for those employers and those employees. So instead of terminating the employee or putting them on some other sort of accommodation, there's this unpaid leave available for reasons related to COVID. So let's just get into some of those reasons. They're quite broad. But an employee can take the IDEL for these reasons and others. But basically, if they have COVID, if they've had a contact with someone who has tested positive and they need to be in quarantine for some reason, if they're following a public health order, an employer can put an employee on the IDEL if the employer is concerned that the employee may be causing exposure to other employees. And so those are sort of the might have COVID type reasons to be on the IDEL. And then the other broad category of reasons are the caregiving reasons. So broadly, an employee can take the IDEL if they're providing care to someone who has COVID or a matter related to COVID. So maybe if they need to support someone who's quarantining, something like that. And then the major reason we're seeing, which is related to childcare. So school and daycares being closed and having to keep kids home is one reason an employee can take the IDEL. And also, if the employee's childcare is available, but the employee does not want to send their kids to that childcare or school due to fear of exposure, they would be entitled to the IDEL in that situation as well. So that's quite broad. They don't need to have a medical reason that they have a fear for their child or anything like that. They can just have chosen not to send their kids to school, and they'd be entitled to the IDEL for that reason. Again, it's an unpaid leave, so the employer doesn't need to continue paying the employee. The employer doesn't need to say, okay, it's fine if you work from home. The employer can just say, fine, you're on an unpaid leave, and that's like a parental leave, or is an example of an unpaid leave. The employee has job protection, and their benefits need to be continued, and they continue to gain seniority, but they're not otherwise getting paid or doing any work. So the timing of the IDEL, it is retroactive to January 25th, 2020. So I doubt we're dealing with any situation that came up in February at this point, but the employee would have had that entitlement back then, and that was before the IDEL existed. So it is retroactive. And their entitlement will continue for as long as the circumstances continue that lead them to need to have that leave. So if they're in quarantine for 2 weeks, their IDEL is 2 weeks. The circumstances of being in quarantine have only lasted 2 weeks. Or until COVID-19 is no longer a designated infectious disease. And that's under a regulation under the Employment Standards Act. So I don't know when that would happen, but it seems kind of unlikely. And it can be taken in partial days. So this is kind of an interesting element of the IDEL. If an employee said something like, I need flexible hours, or like, I can't work on Thursday afternoons. And if their reason was related to COVID, like, my child's care is not available at that time because some COVID reason, like my kid's school is only doing half days or something like that. The employee could basically become a part-time employee. So they because the IDEL can be taken in hours, so they're on a job protected leave when they're not working, even though they might have a full-time job. So it's a bit of a mind bend type of scenario there, but it's kind of a way that an employer can be required to accommodate flexible work or reduced hours. The employee would have that IDEL protection for that time. Proof of entitlement. Under the law, the employer cannot require a certificate from a physician or a nurse. So require doesn't mean you can't ask for one, but you can't require it in order to show proof of entitlement of the leave. And that's more for the situation of like, I tested positive for COVID or something like that. We just don't want to overwhelm the healthcare system with those types of requests. Employers can request evidence reasonable in the circumstances. So that might be like a note from the daycare, or the note from the child's school saying that there's been an exposure in the classroom, something like that. So you can be creative about what can be requested. Other accommodations, just mention these quickly. So employees are asking for a variety of COVID accommodations, like working from home, flexible work. The IDEL only applies to the situation of an unpaid leave. So if an employee is asking to work from home, then IDEL is not going to cover that situation because they're asking to work, right? They're not asking to be on an unpaid leave. So when we're considering other accommodations, we're going to be implicating the human rights code, because that's really the only other way an employee might be entitled to an accommodation. And so we need to consider sort of normal human rights accommodation practices. So asking the employee to substantiate their request. So if they say something like, you know, I have a compromised immune system and therefore I need to work from home, it would be reasonable in that circumstance to request some medical verification of that. And so that would be like a doctor's note or a functional abilities form or something like that, backing up that request. And just remember that the employee doesn't have the right to pick their accommodation. So it's a joint process between the employee and the employer, but you know, it's not just that the employee says this is what I want and this is what I get. The employer has a duty to accommodate to the point of undue hardship and to take the employee's accommodation needs into consideration, but that doesn't mean the employee gets exactly what they might want. Over to you, Lisa.
Okay, so we're going to talk about a new law that passed this week as a key way that businesses can really cover their butt, but not quite the employer, as you will see. So let's start with the good news. Bill 218 in Ontario passed. It's called the Supporting Ontario's Recovery and Municipal Elections Act 2020. For the purposes of this webinar, you can ignore the elections piece of this, and it's the recovery part that I think is relevant. So this is actually good and big news for employers. What this new legislation says is that there is no liability for any COVID-19 infection or exposure where you made good faith to act in accordance with the health guidance and applicable law, provided the way that you acted didn't rise to gross negligence. So to break that down, we know, and I think the government is making it quite clear, they know that there is all kinds of conflicting and evolving advice throughout 2020 to deal with COVID, and they're trying to create this big umbrella liability protection for businesses who did their best, who in good faith did try to act in accordance with the rules that were put in front of them. Now, good faith, let me, if we go to the next slide, I think we start to talk about what this all looks like. The guidance, that the public health guidance that it's referring to is all three levels of Ontario government. So the federal level, the provincial, and the municipal, and the various health authorities and other applicable authority. They add in the sort of generic applicable. So basically, as a business, as an employer, you were given all kinds of different advice throughout 2020 about how to handle this, and we were all learning. Is it transmitted by air, by surface? And so, you know, we remember March and April when we were all in the heart of all the panic around all of this. I mean, I think we're all still triggered by COVID, but in the early days where we didn't know exactly what to do, how to handle it, everyone just made all kinds of decisions that were based on brand new circumstance, no law that we could apply. We were constantly telling businesses and our clients, we don't know how this will all unfold in the courts, how the courts are going to interpret this. You have no choice but to either face bankruptcy or lay off people right now. You know, in some circumstances, you know, businesses had to completely shut for anyone not right on the front line, and all the pivoting that had to happen. So this bill is intended to protect all of that. So the good news is that if you made good faith efforts, and even if there was conflicting or inconsistent guidance from the different health authorities and the laws, but you acted in good faith, then you are protected, meaning nobody can bring a claim, cause of action against you because of it, because of contracting or being exposed to COVID. So it defines good faith as an honest effort, whether or not that effort is reasonable. And I don't know that I've seen this very much. I don't know if you have, Hilary, this idea that it doesn't even need to be reasonable. It just had to be honest and in good faith. Usually the standard is acting as a reasonable person would in your shoes, for example, that whole fiduciary duty type of standard. But in this case, it's just good faith, honest effort. Hopefully you try. I mean, you only need to
tried a little.
I know. And so you didn't have to get it right. Nobody got everything 100% right in 2020. It's been a bananas year, but the honest effort. There's a couple of, and so there's no scientific or objective standard that's being applied either. A couple of the exemptions that are carved out, one of them is that, and this is the bad news for employers. So the act will be helpful for if any customers, for example, are exposed to COVID in your workplace, or vendors or suppliers. But for your employees, this act does not apply and does not protect you if one of your employees contracted or was exposed to COVID-19 in the course or as a result of employment. Regardless of workers' comp, that sits outside, that continues as is, it doesn't impact that or diminish that. All those rights are expressly preserved. But in the context of an employee, one of your employees being exposed or contracting COVID-19, this is not a blanket protection for businesses or employers. So you're not protected from liability. It's a very, very big exemption, if you ask me, because so many businesses were able to pivot online into an e-commerce environment where there isn't any big impact. And then the people who are still in the trenches, either doing the deliveries, producing, cooking, doing all the other stuff, are your employees. So for those that were not able to just work from home, we're going to see how this unfolds. Again, this was only passed on Monday, so we're at the very beginning of this. One notable piece about this is actual or potential exposure. So they really deliberately keep this very wide for employees. The other piece around this is that if you should have been closed because of government mandates and you chose to not close. I know at the beginning there was people who were maybe dancing around the rules a little much because it seems completely out of this world that we would just shut down our economy. I mean, it's almost like a weird normal now, but in March and April, it was so unprecedented. And if you were one of those businesses that did try and quietly keep going and didn't close, you will not get any protection from the whole act. So it expressly carves out any liability protection for any businesses that did not close when they were supposed to.
Yeah. Okay, yeah, we'll see what happens there. So, and just a reminder about employers' duties under the Occupational Health and Safety Act, and this is nothing new, but it does have, I think, good application to the COVID situation. So, and I think we are seeing this a little bit with employees saying, I don't want to come to work because it's unsafe, right? So the employer does have a duty to provide a safe workplace under the Occupational Health and Safety Act. And an employee has a right to refuse unsafe work, but that standard is quite high. So the right to refuse unsafe work requires that the employee feel that they are likely to endanger themselves at work. So we have seen some, I don't think I've seen anything since the summer, but there were several situations where the Ministry of Labor was called in to work stoppages due to COVID. So employees saying, hey, I'm refusing to work because it's unsafe. And I think like one of those out of hundreds did the Ministry of Labor rule that it truly was unsafe. So I think that's again sort of showing that where employers are being reasonable and making good faith efforts, they're being given that leniency. All right, so segueing now into layoffs and terminations. Another perennial topic. So
that's only going to increase, right? As businesses can't keep having their patios for their restaurants and their outdoor stuff. I think we're going to, the bankruptcies will start to hit soon.
Oh, and I just see we just got a question here, so because it's related to our last topic, so I'll just read this out. What if an employer has provided all the necessary PPE to work, but the employee still refuses to work? So I think in that situation, if the employee has legitimately made like a work refusal under the Occupational Health and Safety Act, the employer has a duty to investigate that and then to call the Ministry of Labor to investigate if they can't resolve it. So if you haven't been able to resolve it with your employee and they've actually asserted that right under the Occupational Health and Safety Act, it may be time to get the ministry involved. But in some situations, an employee is not actually really making a work stoppage, but they're just kind of like, I don't want to come in because I'm afraid. And that would be a situation where you would consider their entitlement to the IDEL. So is there any reason like related to COVID that they need to stay home, or their entitlement to a leave or accommodation under the Human Rights Code?
They can't just not show up for work, though. That's, we're starting to see case law come out around that. They need to engage in the conversation. There's a process that's set out in the legislation around the steps to take. You need to have that conversation first. I think where we're going to really see some, and we'll see it all in headlines in the news right now. I know the big reaction to this new bill is around the long-term care homes in Ontario and the terrible situations there. Those employees are facing real, we're going to see what happens with those. They're a really difficult workplace right now, and for the families, it's highly emotionally charged. It's a really sad situation. And I know there's a lot of concern that this new bill is going to protect all those long-term care homes from liability. And so that's where we're going to see the real headlines right now. But those employees will probably have something to say. And that's an example of, if they've been given all the PPE and still might be exposed, it's going to be a case-by-case conversation about whether or not they can refuse work.
And I think in those situations, actually, I should have mentioned on the last slide here, but there is, the right to refuse does not actually apply to every employee. So some jobs are inherently dangerous, and there will be an inherent risk of exposure. For example, like healthcare jobs or police or whatever. So they actually don't have that right because their job is inherently dangerous, and that's just their job. And we couldn't have police asserting work stoppages because they felt their job was risky, right?
Yeah.
And I see we just have another question. When is the employer not covered by Bill 218 other than not closing when they should have?
I think it's nice and broad. It's if you should have closed and you didn't, you're not covered. If you did not act in good faith, or the actions you took rise to the level of gross negligence, which is more than just regular negligence. It's a lot of negligence, and it's a very high threshold. You had to have really seriously screwed up in bad faith to not have any coverage. And then as an employer, as opposed to a business, as an employer, your employees that's a really big carve out in this legislation in general, that you're not protected. Your employees can bring a cause of action against you if they are exposed or potentially exposed to COVID in the workplace. I mean, all the usual stuff, they have to, establish harm and damages. It's not just a blanket, they can sue you for nothing, but there needs to be, this will not bar employees from taking action if something bad happened.
Yeah. Okay, so back to layoffs. So currently, because of the, I don't remember what legislative amendment, but
it's all a blur.
It was a regulation under the Employment Standards Act, converted layoffs during this period to IDELs. So any employee who's on a layoff They are actually not on a layoff right now. They're on an IDEL. Even if you didn't realize that, they are. So this is what, if you do look into our blogs or look at some of our other webinars, this is what we're calling the deemed IDEL, because these aren't employees who asserted their right to this leave. They're employees who are deemed to be on the leave because they were laid off or had their hours reduced. So, so because these employees are on a leave, their service continues to accrue and they need to have their benefits continue. So this is sort of old news, so I hopefully everybody's dealt with this by now. And that recently got extended until January 2nd, 2021. So it continues. So after January 2nd, 2021, we're, as far as we know at this point, back to regular old layoffs. So employers do need the contractual right to lay off an employee, which we found most employers do not have. So that needs to be in a valid employment contract. You have the right to lay off the employee, or the employee needs to have agreed to the layoff. But, you know, that being said, employers are laying off people without that right and just taking their chances. There is a risk of constructive dismissal claims when that happens. You know, the important sort of thing that people are wondering about is, like, if my employee's been on an IDEL this whole time, in some cases since March, you know, when we initially had the shutdown, employees were laid off. That layoff converted to a deemed IDEL. That continues till January 2nd, 2021. And then the layoff clock restarts. So our regular layoff timelines under the ESA are going to be restarting on January 3rd, 2021. So the length of a layoff is 13 weeks if you don't continue benefits, 35 weeks if you continue benefits is sort of the most normal way, but there are other ways you can extend the IDEL to 35 weeks. For example, you can get permission from the Director of Employment Standards. You can have them work a little bit, and those are just the dates. I just calculated those dates. So these are, so April 4th, 2021, if you're not continuing benefits, that's sort of when the layoff period would end, following January, the January end of the IDEL, and then September 5th. So a while to go. So once the layoff period is ended, or if you've made the difficult decision that the employee is just not going to be able to come back because, you know, business hasn't sufficiently recovered, and then we need to think about terminations. So terminations, of course, permanently end the employment relationship. And in most cases related to COVID, we're going to be terminating without cause because the employee didn't do anything terribly horrible that would warrant a cause termination. And when we're terminating without cause, we do need to provide, of course, notice. So reasonable notice under the common law, or a notice may be set out in the contract, but those are things you need to have a look at when considering a termination. And just to go back to our little timeline slide here, a layoff cannot go on for longer than these timelines. So if it did, it would actually at that point be a termination. So the employee would be entitled to their termination entitlements as of these dates, sort of at the end of the line there. Someone's just asked, what is the likelihood that the IDEL will be extended past January 3rd? No idea.
Let me just get my crystal ball out here.
It has been extended once. Like, it was, I believe, supposed to end in, I think it was September, and it was really the night before it was supposed to end. They made this amendment to extend it. So I wouldn't be terribly surprised, but I think it kind of depends on the state of things. Like, if we're continuing to be in some sort of lockdown, Yeah,
The numbers are high, and they continue to be
Yeah.
high, and like right now, it's a really bad second wave, worse than most thought it would be. So, like all of our advice in March and April, it's all unpredictable, and we don't know. It definitely could happen.
Yeah.
Mhm.
Yeah. So, but I think, you know, in those 13 and 35-week timelines they exist for a reason under the Employment Standards Act, right? Like, you can't kind of put your employee on ice indefinitely, is I think the reason they exist. So, employees have been just waiting perhaps on a layoff for us quite a long time already, right? So I don't know. I have no prediction, but that's, I think, a consideration is just the policy implications of like how long can people keep their jobs when they don't have a job to do? Can it be potentially more than a year, which it will be when we consider the time of the IDEL, from last March until now going into April April or September. So a very long time. So
another question here about Bill 218. If Bill 218 doesn't stop employees from taking action against employers, then who does it stop? Just customers or clients? And great question. And I think that's definitely what we're going to see some of the criticism around it all. Some of the articles on this when I was learning this brand new law in the last 24 hours, a lot of the criticism is directed at this really ultimately trying to protect the long-term care concerns. That's really where a lot of the deaths have happened. And so the families of people who have died in these long-term care homes will not be able to sue the care homes. So that's going to be probably one of the business's biggest beneficiary is in that industry in particular.
So I see it is actually 11:02. So I think just to honor our timeline, we will wrap up. Do feel free to get in touch if we didn't answer your question. Here's just our quick takeaways slide, but I'll just let you guys read that yourselves. And of course, you can download the slides in the handout tab of the webinar. And here is our contact information. If you do happen to have questions we didn't get to. Our next Spring Forward legal update will be December the 16th, so right around the corner. And that one we're planning to do an Ask Me Anything 2020 wrap up. So if you have questions you'd like us to address during that, you feel free to send them to us ahead of time, or we can do our very best to answer them live. And I think, feel free to follow us on social. We have Facebook, Twitter, LinkedIn, Instagram, and a copy of this webinar will be on YouTube if you want to rewatch.
You want to binge all of our YouTube videos?
Yes, we probably have hours of content on there if we're looking for a fun Friday night. Although things that we've said in the past may not be accurate given the changing state of the law.
There is that, exactly.
Yeah. So, but anyway, thank you everyone for joining us.
Thank you. Have a good day.